Hello everyone, and thank you for watching our presentation. We propose an interdisciplinary perspective on the topic with the co-authors coming from different backgrounds. Ramona is a PhD candidate at the Faculty of Law, University of Bucharest, and also a practicing lawyer specialized in litigation and arbitration.
Adrian is a software engineer with experience in organizational transformation, agile environments, training and coaching. We will tell you why we think that agile law may be the key to better law. While reactive law seems to be the common practice in lawmaking, but it is misfit for a fast-changing society, and proactive law is the objective to aim for, but it is rather an ideal in the complex lawmaking system, we deem that agile law is the answer, as the middle ground between the two, easier to implement, evaluate, and with faster and concrete benefits for the system in which it is applied. Starting from the success known by the Agile principles applied in the software industry, we look at the features that could be brought in a law system and test them against two different subsystems, the state legal system and international arbitration as a private justice system.
Several elements of agility which are relevant for the field of law and for our discussion today are system thinking, short feedback loops, transparency in decision making, priority based on impact, incremental and iterative action, and reducing handover. System thinking means abandoning the simple cause and effect model and adopting the larger picture, looking at the elements that affect a phenomenon. Moreover, any system has leverage points, aspects that one can change or influence, and constraints or boundaries, aspects which are immutable. Any effort on these aspects would be worthless. Identifying them is very important in order to influence the relevant factors, the ones that can generate visible impact, and avoiding time-consuming and useless effort on areas which are anyhow immutable.
From a lawmaking perspective, system thinking involves zooming out and bringing in various perspectives from the different actors, both involved in implementing a law as well as impacted by its application. This is usually accomplished by industry-specific consultations and public consultations. While in state law, making consultations may take time, is many times only a formality, in the arbitration community when drafting a piece of soft law, the views of practitioners, academics and beneficiaries are all taken into consideration because the success of a piece of soft law, its adoption and use in practice depend to a great extent of its acceptance by the users. On the other hand, in state lawmaking, the law becomes binding for everybody, irrespective of whether the due consideration was paid to the concerns and views of the ones affected.
Short feedback loops involves experimenting and learning rapidly, testing a prototype as soon as possible in order to obtain valuable feedback and adapt the product fast, avoiding huge investments of resources in products only to see that in the end it fails.
From a lawmaking perspective, this means testing a law proposal as soon as possible by making it public or by inviting interested actors to comment. Receiving feedback early in the drafting of the law helps save time and resources by highlighting the flaws and risks from the start. Integrating feedback early in the creation of the law avoids successive changes after the law is already in force, so it helps to obtain better and more stable laws.
Incremental and iterative action means cutting the big problem in smaller problems and putting them in order that makes sense for both the consumer and the producer. It is better to solve step by step a big problem with significant impact on the beginning and less impact towards the end, because the big issues are solved in the beginning and there is less and less waiting time in an uncomfortable state.
From a lawmaking perspective, this means avoiding huge legislative packages and focusing on small-sized targeted laws with fast impact. Avoiding to wait until political agreement is reached on a comprehensive legislative package in a certain area, which would take years, but instead focusing to adopt micro-laws and finally join all of them in a coherent package, if the case.
Business-wise, handover is expensive because one needs to pass their explicit and implicit knowledge for the subject they worked on. That means useful information either documented thoroughly with a big cost of effort and time, or it is being lost. So we prefer to minimize handovers and put everyone to work at the same time, thus creating more implicit knowledge to the group as the subject gets developed.
As regards state lawmaking, the very basic flow for a law initiative to become law involves many points of handover, but it would be difficult to reduce them since there are democratic checks and balances in place.
Transparency in decision making and priority based on impact are self-explanatory and you won't insist on them given the time restrictions.
Jumping to conclusions, we realize that comparing soft lawmaking international arbitration with state lawmaking is not a fair comparison between equals, since the complexity of the two systems differs, the state lawmaking being a far more complex system with many more constraints and variables. Nevertheless, we deem that state lawmaking can learn some tips and tricks to become more agile.
Finally, we put forward 3 questions related to the topic, and we are very much looking forward to your views. 1. How do you think we could reduce handover in the legislative process without sacrificing democratic checks and balances? 2. Is it customary in your state for the citizens to get involved in public consultations? What about the lawyers? Are they more prone to get involved in public consultations? 3. Do you consider that lawmaking is sufficiently transparent in your state?
Thank you all, and have a very good debate.
Thank you.